Hello, everyone. Good afternoon. I'm Michael Morrissey again, and we're just getting started on our second session for the day. So I thought if we can click into the slides, I'll introduce our speakers for this afternoon, and from there I'll throw across to them. So what we're talking about this afternoon is really talking through managing risk through the construction shutdown, and talking about a bit of a dirty word for a lot of people, the concept of insolvency, and what options businesses might have, including to prevent that from happening, to manage themselves through that process, and what some of the opportunities they might have could look like. So we're very fortunate. For those that have logged in earlier in the week, you may have already met Bryan. Matthew's one of our most senior lawyers at Morrissey Law, and has a lot of experience as a legal advisor in dispute resolution and management, and in the insolvency space. And he's joined today by Chad Rapsey, the founder and director of Rapsey, Griffiths Turnaround Plus Advisory. And Chad's one of our go-tos for any advice around turnaround, insolvency and related issues of, I think, Chad, we've worked together on and off for 12 years now. So yeah, it doesn't feel like that long, which is probably a good thing.
We're getting old.
But Chad has some really interesting views, and is really quite progressive in how he and his team approach these kind of risks, and has helped a lot of businesses, including alongside our team, through some fairly nasty scenarios over the years. So we really appreciate him taking the time this afternoon to jump in on with Matt. So I guess I'll throw to the guys. I'll be in the background monitoring questions. So if anything pops up, we'll probably answer at the end. If it's particularly pertinent or relevant at that moment, we'll throw it up into the ether for Matt and Chad to work through. But I'll throw across to them, and I'm sure we'll have the usual disclaimers around this before we jump into a pretty frank conversation. So thank you both.
Okay, thanks for that, Mike. I thought we'd just start with a quick overview of the sort of topics that we're going to touch on. We're just going to have a chat about the warning signs of potential financial distress, what can be done ahead of time, if you like, to try and avoid getting into those difficult sorts of situations, including by keeping accurate books and records. We'll talk about what are known as the ipso facto provisions in the Corporations Act that have been around for a few years now. We'll deal a little bit with what insolvency means in the context of the Corporations Act, and how that definition feeds into the offence of insolvent trading. We'll talk a little bit about what defences are available to directors who are accused of insolvent trading. And then we'll go on to talk about what can be done in order to take advantage of what's known as the safe harbour in the Corporations Act as well, and small business restructuring plans. And we'll cap off with a little bit of a discussion about what happens if it all goes pear-shaped and there's no alternative to a formal insolvency or an administration or liquidation type scenario. As Mike said, or hinted at the outset, we're not intending to provide any sort of specific legal advice by going through the topics we're going to touch on today. Some of those areas can be the subject of a webinar just by themselves. It does get a bit detailed and a bit facts specific in some situations. So having said that, if anyone does have any detailed questions, there's any sort of particular scenario that you want to put to either of us, we're obviously happy to take those questions. And if we can answer them on the spot, we'll do that. If they involve a bit more detailed consideration, then we'll take them on notice and get back to you. So having given that introduction, I might throw it across to Chad to go through some of the typical warning signs that pop up and that are indicative of potential cash flow issues.
Thanks, Matt. So I suppose when we're helping a business in distress, the biggest thing is the earlier that you can address underperformance within the business, the better prospects you have to implement turnaround strategies, and then make sure that the business can then move forward without slipping into either a harsher means of financial distress or then insolvency. So a few of the warning signs that sort of pop up consistently of any business that starts to see sort of financial distress is that you've obviously got some cash flow difficulties. So you're not being able to pay your creditors within those terms or trading terms. Usually you have probably 2 or more financial years of where you've got a trading loss, which indicates some sort of distress that's happening. Not paying your taxes as and when they fall due, so your GST, pay as you go installments or superannuation contributions. If there's legal action that's being taken against for debt recovery means or threaten of legal action, if you can't borrow more money or you've already defaulted on your loans, which is a suggestion that you can't provide or get access to any other cash or capital required to support the business to trade through. Bad record keeping or inability to actually produce financial information, which is really important for you then to be able to make future decisions for the organisation or track where the organisation is actually performing. Usually there's a sign of having a lack of controls or not enough controls within the organisation to be able to produce that financial information or to track how healthy the business is moving forward. Not having a business plan. An often one that we see is where a business grows too quickly and they don't recognise the stress that can put on your balance sheet as to how you fund that growth. So usually, explosive growth is a risk area that we see quite commonly within businesses. Concentrating your risk with too many or not enough customers. So obviously then if you've got one or more quite large customers that if they get into financial distress or then has a flow-on effect to your organisation and the viability of your organisation. Project delays or also defective work consistently throughout an organisation adds costs and inefficiencies within the organisation. The lack of profitability. So usually we see sometimes underquoting or not so much even underquoting, just not adequate quoting on jobs where items have been missed or not contingencies aren't put in place to have enough margin on certain items, creates pressure on the organisation. And we all overlay that at the moment, with the current, COVID-19 restrictions and things that are influencing all sorts of businesses at the moment. Obviously, the critical thing at the moment is the shutdown in Sydney with the New South Wales government at the moment. So
in terms of what we can do to try and avoid those sort of warning signs flashing up and having a situation where you need to go and talk to an advisor, whether it be a lawyer or an insolvency practitioner. The first thing, as Chad just alluded to there, is being able to analyze your financial records and forecast and budget accurately. Just having that degree of financial literacy and the ability to make informed decisions in light of the balance sheet and what the financial records look like. At a more sort of fundamental level, it's important, we think, to have good people and have a good business culture. Obviously going to a place of work where you enjoy your work, you get on with your colleagues, creates a more sort of harmonious environment. Just helps things flow along a lot more enjoyably, obviously. Record keeping, as Chad mentioned as well, it's not only important from the point of view of, well, if I get into trouble and I need assistance, do I have records at hand that I can provide to a professional advisor to help me get an understanding of what particular problems might be arising and what can be done to avoid them or to bring an end to them. It's also a requirement of the Corporations Act, and we've referred there on the screen to section 286 of the Act. So there's two very good reasons there to ensure that the records, the books and records, particularly the financial records of the company, are kept in good order. Over the page there, building business relationships and is obviously fundamental to any successful business. Also, having stable management, having continuity in terms of management is important. In terms of the specific construction context that we're dealing with at the moment in terms of the Sydney shutdown, having the right contract is really important, and this is something that everyone can obviously get advice upon at the outset. Some contracts are less negotiable than others, but generally speaking, our view is that you need to give consideration to those dot points that we've identified there. So know who your contract is with, know the ACN, the ABN of the other party. Be aware of whether you're dealing with a particular trustee company, for example. Deal with reputable parties. You can carry out ASIC and PPSR searches to ensure that as best you can, you're not dealing with another party who might have a history of enforcement action having been taken against them, for example. Winding up applications, things like that will appear. If there's been a change in important or key suppliers, for example, those things can sometimes pop up on PPSR searches. So if someone is shopping around because they've got into trouble with a particular supplier, they've run into credit issues or whatever, those sort of things can reveal themselves. Name changes is another example. If there's a company that's particularly more than once changed their name, then there may be a particular reason for that. The contract price needs to be considered carefully, obviously. There is a temptation sometimes, I think, in a fairly competitive industry to tender for a low price to try and win work, but sometimes that comes at a cost, particularly when things don't go according to plan. Document what the obligations of each party under the contract are. Document it when those obligations change and they're the subject of any variation, and document communications. A lot of the time, things will go according to plan, but having things in writing is very important, particularly when things go bad, the parties fall into dispute, and more often than not, that's as a result of issues and debates over money and who's entitled to be paid what. Identify what has to be done to complete the works. Ensure as best you can that your contractual risks can be controlled, or if they can't necessarily be, and they're to some extent within the control of a third party, see if it's possible to get insurance. Ownership of materials is important, and again, that goes back to the importance of the PPSR, the Personal Property Securities Register. Make sure there's appropriate clauses in terms of retention, bank guarantees, and the last two dot points, in terms of the right to suspend and terminate, including in the event of insolvency or possible insolvency, and step-in rights where you can jump into the shoes or have someone else jump into the shoes of a contractor, for example, and take control of the work. Those types of clauses generally do appear in most sophisticated contracts, but they are subject to the what are called the ipso facto provisions that are set out in the Corporations Act, which, as you see there, they limit the right, and this has been the case as of July 2018, of a party to terminate as a consequence of a restructure, including a voluntary administration, receivership, or scheme of arrangement. So there are exceptions to that rule, and the rule applies differently to different kinds of arrangements. But it's just important to bear that in mind when you're making any decision about potential termination of a contract. So
recapping on that, Matt's probably a few key things where we would see to assist businesses in the current situation is really you got to start stress testing your forecasts and your projects, on a project basis, and also the portfolio, and obviously stress testing that with how you're going to get back to upscale to production on the project. So maybe a tiered process will be that you only got 25 capacity of workforce that can go to the site, then 50%, and then what does that look like for your profitability and managing the costs on your projects. Then that falls down into your understanding of your cash position, to making sure you've got adequate cash support and resilience within your balance sheet to protect the organisation to get through any challenges that might get thrown up with the shutdown and any flow-on effects from there. So if you can identify early that you may need some cash at a certain period of time, start engaging with your plans about how you're going to bridge that gap. So you either start talking to your funders early in regards to that, or whether there's equity or other options that you have there. So really understanding your cash position is key. And I suppose utilising the moment with the shutdown is where I see as a really big thing is that getting your staff to collate evidence on outstanding claims and things you've got at the moment, so you're getting really prepared in the downtime at the moment through the shutdown. Look at coordinating with your suppliers about, deferring supply or when you're going to be able to upskill, and then obviously engaging with all the customers and creditors and your staff about working together as efficiently as possible to get back up to be productive when the shutdown finishes. So, and obviously then overlapping there is managing staff morale, is probably a key thing through this process as well. So.
I think that's a very good point, and the fact that people might not be able to actually perform construction work at the moment doesn't mean that there aren't things to do that have a big impact on the business generally, but also the extent to which they're going to be able to sort of pick up and resume work, hopefully on the 31st of July.
Yep. So then we get into looking at what actually insolvency is. So insolvency under the Corporations Act is really a simple definition that you're unable to pay your debts as and when they fall due. So the first thing that we look at and the test we look at is a cash flow test, looking at whether the business can pay its debts when they're due and payable. So we look at your like a cash flow forecast or your aging of your creditors' terms and those sorts of indicators on the first instance. The second instance is a balance sheet test. So whether the business has enough resilience in its short-term assets to cover the debts when they're due and payable. So there's a big difference between a short-term liquidity problem, which is only a short-term and temporary thing where you mightn't be able to meet obligations in the short term. But there's a bigger analysis that you would do as to whether that's a longer term, unable to pay your debts when they're due. So when we look at insolvency, so one of the main things is that there's a duty for directors to prevent insolvent trading. So as I said, we look at the cash flow test, and obviously then moving forward, the director has the duty or obligation not to incur future debt, knowing that potentially the business can't pay for that debt. If that's the case, there's obviously then some risks that then come along with that, and then we can probably later in the webinar we can talk about how we mitigate some of those risks for directors to continue to support a turnaround or to help revive the business if it's facing a bit of distress. So there are breaches and potentially personal liability for directors for incurring debts when a company is insolvent. So just got to be mindful of that. There's criminal and civil penalties around that. So we just need to be really mindful and confident, if the company is in distress, working out how distressed it is, and then before it gets to that point, putting some risk mitigation strategies in place to then help support the business, and then obviously ideally turn the business around and make it viable again. So
it's important, I think, as well, to just emphasize that people who see the writing on the wall and plow on regardless are subject to harsher penalties typically than people who just run into problems and seek help at an early point in time. I think there are six-figure fines that are applicable, but the penalties really ramp up when the court considers that there's an aspect of dishonesty involved as well. So, and that obviously makes it more likely that a liquidator or some sort of creditor who is able to fund court proceedings might bring a civil claim as well to try and recover some money.
Yeah, and usually in that scenario, Matt, we see a lot of potential business owners. Obviously, it's quite of a challenging period when a business is in distress or having some challenges. But the people, the directors that stick their head in the sand and probably don't be proactive in sort of mitigating that by engaging experts and professionals and legal advice to assist them navigate sort of path through. They obviously just try and stick their head in the sand, and then unfortunately then the position gets worse and worse, and then the options available to help revive the organisation or get it back to being viable get more difficult as the distress gets worse. So it's really key to engage early. So
yeah, and I think there's a particular emphasis in this area, I think, on the cash flow test as opposed to the balance sheet test, where sometimes a company might have assets available, but if it's going to take substantial time and there's going to be difficulties associated with, for example, selling property, then it's really about whether or not there's enough cash flow there in the short to medium term to satisfy the debts, as opposed to what it looks like on the balance sheet a lot of the time, or at least that's what I've found when dealing with some of these matters over the years. The directors really need, at the end of the day, to stay informed about the company's financial position, and as Chad just mentioned, you need to take action as soon as there are some of those warning signs that are indicative of the company being in distress. Obtain professional advice and do so as quickly as possible in the circumstances. So in terms of defences to insolvent trading, Section 588H of the Corporations Act sets out 4 possible defences, which are up there on the screen. So if there's a reasonable basis on which to expect, and a person did expect that the company was solvent and would remain solvent in spite of a particular transaction, that can be a defence. As a defence of reasonable reliance on information, provided that that information is coming from a person who is suitably qualified, objective, and provided that the advice is not just accepted blindly. So generally speaking, there would need to be some evidence of the fact that the advice was understood, that it was realistic, and that any appropriate questions were asked and the answers considered in the context of reliance upon that defence. If there was an absence from management for some good reason, that can be a defence. So if a particular director had a stint overseas and, for example, appointed an alternative director in his or her absence, that might be a defence. Serious illness or lengthy illness is also a factor in that context. And the final one there, that the director took all reasonable steps to prevent the company from incurring the debt. That applies typically where there are a number of directors, or there's some, I suppose, element of dishonesty about a particular transaction being entered into. I can't recall a case where that I've been involved in, at least, where that defence has been successful, and it typically doesn't apply where there are sole directors, obviously, per the typical sort of small construction business where the director of the company is also the person running the show. It'll be difficult to establish that all reasonable steps were taken to prevent the company from incurring a debt, unless there's some sort of fraud committed, for example. So, Chad, did you want to talk a little bit about the safe harbour provisions?
Thanks, Matt. Safe harbour is a really good risk minimisation or mitigation tool for directors to put in place when they think that their business might become insolvent in the future. So the earlier you get this protection, the better. And what it allows directors is to take some more risk in regards to putting in a turnaround strategy than otherwise would be available if this wasn't there. So what in safe harbour is, it's a defence to insolvent trading for the director. So it's mitigates those civil liability provisions and of incurring more debt to turn around a business. But there needs to be some key things that the organisation needs to do to be eligible for safe harbour. So essentially, there needs to be a genuine turnaround available, and it's what's called a better outcome test. So essentially, the business needs to be pursuing one or more avenues that are more reasonably likely to provide a better outcome to the company than an immediate appointment of a liquidator or an administrator. So this is put in place then before you start the turnaround. So you're protected, the director's protected for incurring new debts to then support the turnaround strategy to move forward. So to making sure that you need to be informed about the financial position of the company through this process, you need to be taking positive steps to prevent any misconduct that's happening or could be happening there. You need to be keeping proper records. So it's really vital that accurate and timely financial information is maintained through this process. Then we look at developing, what the plan looks like, and then implementing that plan and then checking in through that stages, and ensuring that the company's paying its employee entitlements. So to be eligible for the safe harbour protection, you need to make sure that superannuation is being paid. Employees' leave entitlements can be paid as and when employees take leave and things, but you have to have the superannuation obligation paid. The other thing is your tax lodgements need to be all up to date. You can't have any unlodged tax returns or BASs. They can be owing, so you can have a debt there, but they must be lodged and up to date. So.
Well, I think one of the most important things in this area is that first dot point there, that all of the steps that are taken in connection with the formulation of a safe harbour plan need to be documented. And I think that's most important, because the protection starts when there is sufficient evidence of that plan. So board minutes need to be maintained, file notes, obviously records of any professional advice that's received. And look, ultimately, what forms part of a particular turnaround plan is obviously going to differ from company to company. But there's some examples there of the type of issues that need to be taken into account. And so, Chad, in your experience of those the most obvious things that companies and the directors need to focus on when they're formulating a plan?
Yeah, so I mean, there's going to be multiple things that are happening as part of the turnaround plan, and as you said, it depends on the circumstances of the business, what projects they've got on, what sector they're in, and different variables that are there. But the underlying sort of things are probably pretty consistent. You're really focusing on improving cash flow in the short term, so you're stopping any unnecessary or luxury spending, to conserve cash flows. Looking at your current labour requirements, to making sure that you right-size the business for, not being unproductive with carrying too much labour within the organisation. Looking at your management structure and streamlining some of that. Looking at your profitable or unprofitable jobs, and critically assessing those and working out, if you need to exit out of some of those unprofitable or unviable projects. In the background, obviously, then you'll be negotiating with your lenders, your shareholders about either recapitalising the organisation or supporting the balance sheet to get through the turnaround phase and process. And usually there's a multiple things that you're all considering at that time then to put in place to then monitor and work towards moving forward. The big thing in doing a turnaround plan is the communication between stakeholders is really important. Different stakeholders would require different information and maybe a different sort of different level of channel in how you communicate. So usually we map out a stakeholder engagement plan to then tailor how we communicate and negotiate with the different levels of stakeholders within the organisation and also outside the organisation. And then obviously then we continue to work with management about the implementation of the plan and continually check in through different key milestones and things to making sure that the plan's still on track, is still viable, and you're still prevailing yourself from those safe harbour provisions that are there to protect you to make those decisions moving forward.
So the other alternative is what's been introduced as a consequence of the COVID difficulties that started last year. So, Chad, as of the 1st of January this year, you've also got the option of the small business restructuring plan in certain circumstances.
Yeah, which is a key initiative that the government put in place as a direct result of the COVID pandemic to try and assist and make it more cost effective and easier for small businesses to turn themselves around. So the key element in the small business restructuring plan is that it's for small businesses. So you have to be a company, unsecured debts under $1 million. You have to have paid up all your outstanding employee entitlements for superannuation. Once again, employee annual leave entitlements can still accrue and would be paid when people take leave and things, but you can't have any outstanding super owing, and your tax lodgements need to be up to date. So, but one of the key things around this process is that it's a debtor in possession model. So the business would continue to operate under the stewardship of the current management team, and you would engage a small business restructuring practitioner to sit off on the side to assist with putting up a proposal to your creditors if the company is insolvent. So under the plan, we would look at what property is available to offer to the creditors. So that could be from contributions from the owners through capital or additional debt being raised through the owners of the organisation, through trading profits into the future. So we would work together with the organisation to come up with what that plan looks like. We lodge that with ASIC. Then we send that out to creditors for their consideration to vote on. When that goes out, they've got about 15 days to consider that. And it's all virtual meetings, so no formal meetings anymore under this regime, where you would send out some correspondence to what the deal is to creditors. And then if the majority of creditors vote in favour of accepting that compromise or that restructuring plan, then it gets implemented and then moves forwards for there. One of the big things on this is that it significantly reduces the costs compared to a formal administration because it's a debtor in possession. So the directors continue to manage the business and trade the business. During the restructuring plan period, the costs are significantly lower, and there's a fixed cost, which is good because then you've got some clarity and consistency of what that's going to happen. And then obviously it's probably a better outcome for creditors to support the organisation moving forward. So, yeah.
So if despite a company or the director's best efforts, the turnaround attempt fails, then ultimately you need to consider the formal insolvency type arrangements. I think it's fair to say that what is most suitable to a particular company will depend upon the exact facts, the exact circumstances that are involved. But for example, in the construction industry, when you're weighing up whether to go into liquidation, for example, it's important to consider the impact that's going to have on the existing contracts that you might have on foot, on bank guarantees that you have provided, or personal guarantees, which are obviously quite common, particularly in terms of getting arrangements in place with suppliers. And in the residential sector in particular, consideration needs to be given to the impact it's going to have on home warranty insurance and also licensing issues. So, for example, fair trading and also iCare, the insurer, will tend to crack down as soon as there is a hint of insolvency. There's also work health and safety issues there that need to be considered as well. So we've got some notes here on three of the sort of typical sort of scenarios that you see. There's voluntary administration there's a deed of company arrangement, and also liquidation. So, Chad, in your experience, is it the case that people will, to the extent they can, explore administration prior to liquidation, try and work out of trouble?
Yeah, I mean, in any sort of scenario, the owners and directors of the business want to ensure the entity survives and is viable moving forward. Depending on, as I said before, if there's the company's experiencing some distress or maybe underperformance, if those issues aren't addressed, then that becomes distress. And then if that's not addressed, then it becomes insolvent. So the closer the organisation gets to being insolvent, the harder it is then to probably implement, turnaround strategies and things. So you always want to be, focusing on turning around a business if you can, and depending on how bad the circumstances or the distress is depending on sort of what other options you've got. But the voluntary administration is a tool, the formal tool to turn around a business that's in distress. So obviously, if we can do that, if we can do it informally beforehand, that's probably better. If the crisis is too significant, then we have to look at some sort of formal restructure, which is a voluntary administration, or the small business restructuring plan that I spoke to just before. But essentially, under administration, what we do is similar to the small business restructure. Is that you appoint an administrator who essentially takes control of the organisation for a month. Obviously, we would want to still have a really good relationship with the directors and the managers, because they know more about the business than an administrator would. We just maintain control for that month. Person will guarantee any expenses that are incurred and can trade the business. So then we can work with the business owners to put up a plan, or what it's called, a deed of company arrangements to its creditors. Obviously, before we would do an administration, we would sort of canvass all these issues and look at all the complexities before we move forward. So essentially, then we will put up a proposal to the creditors to compromise the amounts that they're owed. So instead of being paid 100 cents in the dollar, they might get 30 cents in the dollar, compared to if the business closed, they might get nothing. So we work with the owners to formulate that plan, which can be quite a variety of reasons, putting in more capital, trading profits, selling assets within the business, different sorts of options and structures, to be put into place to try and salvage the entity or the business moving forward. So
I think this highlights again the importance of doing something as soon as possible and getting professional help as soon as possible, because there's much more flexibility, obviously, in terms of the deed of company arrangement type scenario than a liquidation scenario. But if the waters have already been poisoned and the situation is just irretrievable, then sometimes there's just no choice. So again, I think it highlights the importance of not sort of burying your head in the sand.
Yeah, Matt, I'd concur. So there's a lot of businesses that will come to us to try and help rehabilitate them, but unfortunately, they've taken that stance and they haven't done anything and addressed the underlying issues for quite a long time. And the position's so bad that you don't have any other alternatives to try and assist to turn them around than probably looking at a liquidation to try and minimise or mitigate any more problems or risks that are there. So
yeah. Well, that's our last slide there. Just the importance of asking for help sooner rather than later, to improve the chances of being able to undertake that successful turnaround. If anyone out there has any questions, whether now or later on, in light of the issues that we've discussed, obviously feel free to reach out to us at Morrissey Law, or to Chad and his team at Rapsey Griffiths.
I guess I thought I'd throw one out that sort of popped up a few times when people have been talking to me. It's probably more directed to you, Chad, but 2 weeks of stop in work with potentially the associated delays in assessing claims and getting paid. It really, people do need to start to think about this pretty seriously. It's not something. I mean, we schedule for the Christmas shutdown for a lot of projects, and if you get very unlucky, you might get 2 weeks of bad weather. But this is it's reasonably unprecedented, isn't it? In terms of a bang shutdown, you can't really do much at all.
Yeah. It's I mean, it might only sound 2 weeks. 2 weeks is only a short period of time, but I think the actual impact for a business, can sort of have a larger tail as to how that affects your trading, your profitability into the next 1, 2, and 3 months. So I think in a crisis, the construction industry is in this 2-week shutdown period, is probably a lot of operational, logistics issues considering right now. But I think the management teams really need to be considering the longer term impacts, and then starting to put in sort of risk management sort of issues about, what's our funding look like? Have we got enough capital in the business to support us through these ups and downs? Are we going to encounter another shutdown? Is our business, balance sheet resilient enough to carry some of those sort of unknown obstacles that might be thrown at the business sort of over the next 6 months and things? So really don't get stuck, as much as it's critical with the current operational stuff. I think you should not underestimate the potential longer term sort of issues, that financial issues a shutdown could cause.
Right, thank you. I think it's not someone's going to be carrying the cost of this, I guess, and that's one of the hardest things. And it's going to be we spoke earlier in the week about contract to contract COVID cost is shared around in very different ways. So even some of the principals and people running projects we've spoken to are feeling nervous because if they're the ones bearing this cost, it's a lot of extra cost potentially over the course of 2 weeks, including around the delivery of the project.
Yeah, and I think that's probably the critical thing at the moment is a lot of negotiations happening, and depending on how good your relationships with your contractors and your head principals right down to the small guys is to really sort of cooperating and banding together to making sure that not one party's sort of wearing all the risk. And I suppose if you can sort of get together and manage that process as best as possible, then obviously that helps the collective, to complete projects and to move forward. So
yeah. And for the people about to enter into details, it's sort of a moment to stop and take stock, I guess. We're dealing with a few tenders at the moment that are coming to a close, and how people were planning to deal with COVID was slowdowns, not shutdowns. And this sort of reshapes that landscape, and what that risk might look like before you sign a contract is going to be very important.
Yeah, that's massive, Michael. It's creating that flexibility in your contract is probably one of the most critical things, I think, moving forward while COVID's around, because we've just got so much uncertainty.
Yeah, awesome. Well, thank you, Matt, and thank you, Chad. I think coming up tomorrow, like we've got some general Q&A. We've covered. And we appreciate people's patience with this. We've covered a lot of material this week, starting with what the orders are or were. So they have shifted around a little bit. I think we've tried to keep it as current as possible for you with the shift in sands. Probably the biggest changes have been around government grants, not necessarily the shape of the shutdown. But we're going to talk through payment, we're going to talk through employment, we're going to talk through insurance, we're going to talk through corporate obligations and where everything really is at the moment, and try and answer some of the curly questions that have been thrown to us both in these sessions and over the course of the past week. We've got, if you go to the Morrissey Law web page, we'll have all the relevant links and copies of the material up and shared. So please feel free to jump on there and grab anything if you think you've missed anything. There's access to the slides, to the recordings, and to relevant fact sheets around it as well. Firstly, thank you, Matt. Really appreciate the hard work you're putting around this and the volume of work you're doing with businesses. And a very big thank you to you, Chad. We appreciate, we called you up and threw this at you on short notice. And that was, for both of you, that was quite a phenomenal session. I know there's a lot of material covered, really useful, really relevant. And I guess from my perspective, and I'm a business owner as well, I guess. But speaking to people like Rapsey, Griffiths is really critical. Like, you don't delay; it's just getting in front of you. And I think we've seen a lot of success when we've had mutual businesses we've worked together with get turned around and continue to succeed. So we really appreciate you coming on and sharing your thoughts. And yeah, Q&A tomorrow. Reach out, check out the website. If there's anything, Chad, Matt's and the general details are there. So please don't hesitate to contact anyone. So thank you very much, and have a good afternoon, everyone.
See ya.
Bye.